All right, let's get started. Welcome everyone to our next webinar in our Digital Transformation Academy. So this webinar will be on AI literacy and prohibited practices under the EU AI Act. And we are very happy that you're joining us today. And this means if we go to the next slide, my colleague Julia Marius, partner in our Milan office, my colleague Dan Whitehead, partner in London, and my name is Martin Pflüger, and I'm located in Germany. Let's move directly to the agenda for today. We're going to give you a quick introduction on why we are here today, what's the current status of the AI Act, and what is the first set of provisions that became applicable. We're then going to dive deeper into AI literacy and then take a look at the prohibited AI practices. The webinar will be recorded and you will receive the slides at the end of the presentation, so no need for you to take notes. You will also have the possibility to ask questions via a Q&A function. So you see this at the bottom. Feel free to ask those questions. We will be happy to answer them on the fly or at the end when we have some more time for Q&A. If we don't have the time to get back to you in this webinar, we will be happy to reach out to you and answer them via email after the webinar. So thanks very much for joining, and I will give it to Dan for the introduction.
Thanks, Martin. And I think maybe just to take a step back, first of all, so that the purpose of the webinar is really to dive deeply on the particular obligations that took effect earlier this month, specifically AI literacy and prohibited practices. But more generally, the AI Act has a much wider scope of application. So for those of you who have not been following the developments in this area, the AI Act was first introduced by the European Commission in 2021, when the world of generative AI was really only just in its formative stages, and some of the most popular chatbots and LLMs that we see on the market today did not exist. And the legislation evolved over time to include a number of additions that weren't part of that initial legislation, including, for instance, the introduction of rules regarding general purpose AI models. And the other provisions as well evolved. But where we got to is that on the 2nd of August 2024, the actual final text took effect. And then 6 months following that, the applicability of the provisions relating to prohibited practices and AI literacy took effect. There are now a series of other deadlines of increasing significance over the coming 2 years. So on the 2nd of August this year, 2 things will happen. The obligations relating to providers of general purpose AI models. So that's large language models. It's many of the generative AI systems we see on the market. The developers of those systems and also those who take those underlying systems and then configure them for particular purposes potentially may fall within the scope of those obligations. And those take effect on the 2nd of August. In addition, right now, although the prohibited practices are actually in effect, the basis for enforcing them through the regulatory authorities is not yet in effect. So on the 2nd of August, that will then apply. And then we have a little break to take some breath. But 12 months later, the core obligations relating to high-risk AI systems will come into application on the 2nd of August 2026. And that applies to all of the applications that are listed in a particular annex called Annex 3, which are the kind of general applications where there's specific use cases of AI that are considered to be high risk and will be immediately subject to the regulation. And then a year after that, there's also a range of existing harmonized legislation and product legislation, areas such as medical devices, some areas of transportation, etc., and toys, for instance, where harmonized rules already apply to those systems, but also the high-risk AI requirements will as well from the 2nd of August 2027. So there's a kind of 36-month timescale for the implementation of the entire Act. One final nuance here, which is worth bearing in mind, is that these applicability dates don't apply immediately to everything. So the Act really focuses on the future, so new products or new AI systems and new models that are being placed on the market. For those that are already available and used in the EU, so for instance, if you've got an AI system that's already being made use of or sold within the EU today, and it's high risk, the obligations will only apply if there's a substantive modification made to that system after the 2nd of August 2026 or the 2nd of August 2027. So it's quite a complex set of dates, and it needs careful thought about when obligations will apply to particular organizations based on your own AI strategy and use of AI.
Thank you, Dan. So in the course of this webinar, we're going to go to guide you through the applications of the principles on AI literacy and AI prohibited practices in a practical way by making reference to a use case exercise. And this one is our baseline use case. We'll try to unpack the potential legal issues arising from the development of use of certain AI technologies. We entirely made it up. So any reference included in this exercise is the product of our imagination. Any resemblance to actual events or activities that may be similar to what your company does is purely coincidental. So we have a company Alpha that is part of an international group established in the EU. And Company Alpha manages and runs an online platform where it offers 3 different services to European customers: a gaming service, social media service, and an online sale platform. And Alpha, like many of you, is currently evaluating whether to adopt some AI-based technologies. The first one would be a chatbot to be embedded in its online sales platform with a view to advise clients and make their buying experience better. The chatbot is based on a third-party large language model technology, but Alpha is currently fine-tuning this chatbot on the basis of first-party data, so it's customer data. And this is being made by a dedicated division within Alpha that we can call the Generative AI division. Another AI technology that Alpha would like to adopt, this time a proprietary one, is another LLM-based technology that would be integrated in the gaming service of Alpha, and that would allow for the creation of avatars that interact with gamers. And with a view to make the interactions and the exchanges with gamers as realistic as possible, the Gen AI division in Alpha is training the AI system with a view to resemble real or historic characters. The first AI system is being evaluated, its adoption is being evaluated by the HR department of Alpha, and this system would be aimed at making the life of Alpha's employees and work better. The AI system is offered by a third-party provider, and it would entail the detection of employees' emotions based on certain indicators, the written test of employees, but also other characteristics such as their facial and body expressions, their keystrokes, and eye movement. And the final goal of this system would be to provide personalized training to employees in order to educate and support them to identify their emotions and limit burnout situations. So you don't need to learn by heart this use case, but just keep in mind the main points, because we're gonna go back to this in the course of our webinar. And I leave the floor to Martin to give us an overview and to set the stage on AI literacy.
Thank you, Julia. So yeah, let's take a deep dive into AI literacy and how this applies to Alpha. Let's start with the legal principles. Under Article 4, companies are required to ensure a sufficient level of AI literacy of their staffs and other person dealing with the operation and use of AI systems on their behalf. So this provision applies to providers and deployers of AI systems and also general purpose AI systems, but not Gen AI models, regardless of the risk of the system. So if you think your company does not deploy or use high-risk system, AI literacy applies to each and every single company. As a provider and deployer of AI, you have to ensure to your best extent that there is a sufficient level of AI literacy of your staff, so your employees, but also other persons dealing with the operation and use of AI systems. This could be your contractors, maybe your supply service providers, but potentially even your clients. And the AI office generally highlights that this goes well and plays into hand with the general provisions for a high-risk system on transparency, instructions of use, and human oversight. The provisions, the AI literacy need to take into account the technical knowledge, the experience, education, and training that is available within the company, the context of the AI systems that are to be used, and also need to consider the groups and persons on whom the AI systems are to be used. So this really requires a tailored approach, and let's take a deeper look into this on the next slide. Under Article 3, Para 56 of the AI Act, AI literacy is defined as the skills, knowledge, and understanding that allows providers, deployers, and affected person to make an informed deployment of AI systems and to gain awareness about the opportunities and, most importantly, about the risks and possible harm that AI systems can cause. So this is generally breaking down into different components. First is understanding the technology. So you have the skills, knowledge, and understanding, and each and every employee needs to have a basic understanding of how the technology they're using or that is being used really works. The other aspect is the understanding the legal framework. So this is taking into account the respective rights and obligations. This means the framework under the AI and also potential other legal obligations applicable. The next component is understanding the opportunities and risks. So the AI also focuses on the opportunities that I bring to companies, but obviously also on the potential risks for the rights and freedoms of individuals, for their safety, and also general business risks that bring AI usage with. Let's think about intellectual property or privacy. And all this needs to be done in the context of this, how these specific AI systems are to be used in relation to those specific AI systems that are deployed within your organization. So how do you build your AI literacy program? The first step is obviously to analyze the training needs and develop your training concept. And the most important takeaway, this is not a one-size-fits-all approach. So you really need to think about which AI systems are used in my organization. What is the role of my organization? Is it acting as a deployer or developer of AI? Who's dealing with AI systems in my organization, my staff, but potential contractors, other persons? And what are the risks of those specific AI systems that we are using within the organization? So which persons need which level of AI literacy? Is there already a general awareness, understanding that you can build on? And different groups of people may require a different type of training. So this concretely builds your AI training concept, and then you roll out your training concept to employees and other persons according to the required level of AI literacy. And the good news, there is some flexibility around this. So this is somehow also common sense in the way you design your training programs. There's typically different levels, a basic foundational training for users, some intermediate advanced training for those people specifically involved in the deployment of certain AI users, and maybe an expert specific training that can also be in person as opposed to e-learning trainings for those that have a specific role, decider role, important role within the organization. It's always important to highlight that it's very a key aspect is to establish the AI culture within your organization. People should really also understand by practical examples the benefits of the AI usage and also the risk of the AI usage within your organization. And then as every training concept, this is a ongoing process. So the notion of AI may change, your AI system usage within the company may change. So you always have to ask yourself, is the training still up to date? Are there further requirements to enforce the training? Do you need to build out and extend your AI literacy training? So going on the next slide, just a few takeaways that you can read on yourself, but to give you one important aspect, there is further assistance out there from the AI office in the EU Commission. There is a living repository which presents examples of practices of companies that are divided per implementation side and their sector on how they have approached the topic of AI literacy. So members of the AI Pact under EU Commission have published how they approach this AI literacy requirement. And this is going to be developed further and gives you also some practical examples of how other companies are implementing AI. And what does this really mean for Alpha? And that's up to Dan, and I give it to you.
Thanks, Martin. Yeah, so I think if we apply this to our case study, I think something that's notable from the the AI office's guidelines or repository. I don't think they're necessarily guidelines, but a repository of examples of AI literacy, is that there's a significant amount of flexibility in how you interpret this obligation. And also that it's intended to be something that is appropriate to the organization in question, how it uses AI, which I think is a broader point as well about how the AI Act applies in practice, which is it doesn't apply in a blanket or kind of single linear way to all companies. Instead, it's really specific to what role you play in the AI supply chain, how you're using AI, what risks there are associated with that. So if we think about Alpha, I think they're quite a kind of standard company in many senses in the current economy, where they may not directly be considered an AI company. They do lots of different things, and ultimately they're both maybe dabbling in the development of AI or the configuration of existing AI models for particular products, launching their own LLMs for particular purposes, such as the avatar example that's been mentioned, but also using third-party tools internally. And therefore, they're likely to be considered both a provider and a deployer of AI systems and maybe even GP AI models. And the effect of that is, I think that from a literacy perspective, they're going to have to think about not only providing kind of blanket level AI awareness for the entire organization, but also some quite tailored guidelines and training for specific groups. So I think one way that could be framed and implemented, which we're seeing certain clients considering as well, is you have an organization-wide AI literacy program, which may be an e-learning webinar or something equivalent to that, and maybe a series of different webinars or other ways in which employees can access this information, podcasts, videos, whatever it may be, which provides the information about the baseline requirements for AI, responsible AI, and compliance with the AI Act. And then in addition, alongside the kind of company-wide literacy requirements or literacy program, there's also a need to be quite specific on certain groups. So let's say engineers and data scientists that are working on building the avatar large language model, they're going to need some specific training around the requirements that are imposed upon them and the expectations that apply to them. Similarly, those who are responsible for procuring AI systems, maybe the procurement team and legal, will need to understand the risks of using third-party tools and the types of due diligence and contractual obligations and ongoing monitoring that may be required from third parties in order to ensure compliance with obligations. But it's not just about compliance as well. I think it's worth emphasizing that the AI literacy definition goes a bit beyond that and is talking about not just risks or requirements or obligations, but also broader risks and also actual opportunities of AI. So I think there's an opportunity to actually combine both how the organization sees its AI strategy in a positive sense. You know, they've got these huge range of interesting and very valuable and useful AI tools that we may be able to use, but on the side of that, also how to use those tools safely and responsibly and in adherence with legal obligations. So I'll hand over now to Julia, who's going to talk us through prohibited AI.
Thank you, Dan. So, as you all know, the AI Act relies on a risk-based approach. So different requirements apply in accordance with the level of risks. And prohibited practices are those posing an unacceptable risk because they conflict with values of the European Union and represent a clear threat to fundamental rights such as safety, data protection, or equality. The prohibited practices are listed in a comprehensive way under Article 5 of the AI Act, with additional guidance being provided in recitals 28 to 48. And in a nutshell, they provide a clear view of what AI can and cannot do within the European Union. The prohibited practices are 8 in total, and we're gonna see those in detail, a little bit in detail more in a minute. It's important to stress that there are also exemptions applying to the prohibitions, and we're gonna see in the practical part of this webinar how carrying out a case-by-case assessment is key in order to understand whether a certain AI system may fall under the prohibitions or not. The list of the prohibited practices as appearing in Article 5 is exhaustive, but is not final, because under the AI Act, the European Commission has the power of reviewing and assessing on a yearly basis this list. So you shall look out for potential updates in the forthcoming years, and the current prohibited practices should be seen as a starting point. It's important to understand that prohibited practices are operator agnostic, as they target the placing on the market, the putting into service, and the use of AI systems in scope. And the idea is really to cover the whole AI chain value and make sure that such practices are banned as a whole from the European markets. And in practice, this means that the prohibition would cover the supply and the use of any AI system in scope, regardless the way this is done. For instance, this may cover both in-house development or purchase from a third party. And it's also important to stress that this is clarified in the European Commission guidelines that is being published on February 4th, that it's not relevant how the AI system would be made available in practice, be it access to the AI system, downloads, or physical supply. It's also important to note that the concept of use here needs to be interpreted in a very wide way. And this would include also misuse, reasonably foreseeable or not, and regardless the existence of potential contractual limitations in between the provider and the deployer that may limit or exclude a specific use. So the approach here is really a practical one. As Dan was saying in the introduction, the sanctioning regime for non-compliance with prohibited practices is not in place yet. The fines would be the higher fines under the AI Act, up to 35 million euro or 7% of the total worldwide annual turnover in case of undertakings, whichever is higher. It's very important to stress that in spite of the fact that such provisions are not applicable, the prohibitions are already in full force. So non-compliance with such provisions may have other consequences in terms, for instance, of civil liability or the possibility for affected parties to request interim orders or obtain judicial remedy for the unlawful practice. So it's very important to check as of now already whether the AI systems you're using or deploying may fall under the prohibited categories. As I briefly mentioned, on February 4th, the European Commission issued its long-awaited guidelines on prohibited practices. For those who have read it, it's a 140-page long document, so it's really comprehensive. It's even more comprehensive than it would seem, because beyond addressing in detail and with practical indications all the 8 prohibited practices, the guidelines also provide indications on other key issues under the AI Act, such as its material scope, the interplay and overlap with the AI Act of other European regulations, and also the importance of applying an harmonized interpretation of prohibited practices across Europe, and the obligations for competent authorities to act in accordance with the sincere cooperation principle. We're going now to move on the analysis of the 8 prohibited practices. Lamentably, we're not going to have the time to go in depth into all of them, but in the practical part of this webinar, in a few minutes, we're going to deep dive on some of the practices. Sorry, do you still see my screen? Okay, because I'm just having some. Okay, great. So a first group of prohibited practices, namely the first 2 that you see here on the first row, address AI systems that may distort the behavior of an individual or a group of individuals, causing them significant harm. And in particular, this may be done either by deploying subliminal, manipulative, or deceptive techniques. And then Dan is going to explain to us in the use case some example, but this maybe is, for instance, audio or video stimuli embedded in the AI system, or by exploiting vulnerabilities. And the guidance of the EU Commission mentions in particular age, disability, or specific social or economic situations. As I said, we're going to unpack these two prohibitions in the practical sessions of our webinar, but here it's just important to stress that for those familiar with consumer protection laws, such prohibitions echo in a way the mental model behind unfair commercial practices. So differently decline, obviously taking into account the rationale of the AI Act, and the guidance of the EU Commission clarifies that similar to the test under consumer laws, it is sufficient that a given practice is likely to impact on an individual or group of individuals, making reference to their decision-making, individual autonomy, and free choice, taking into account the average individual, even though specific cases may be assessed from the specific perspective of a given individual. And then the concept of significant harm is also common to both the subliminal techniques and the exploitations of individuals, and the guidance includes some practical indication explaining this threshold, but it's important to stress that also the recital of the AI Act recall that advertising and some other commercial practices that depend in a way on nudging are not prohibited. So the intent here is not to prohibit common, legitimate, and lawful commercial practices, especially in the field of advertising, and the approach should be just a restricted one. And that's why I was saying a case-by-case assessment is going to be key to understand whether a specific practice may fall under a prohibition. The third prohibition, social scoring, basically targets classifying individuals or groups over a period based on their social behavior or specific personal characteristics. And social scoring is not prohibited as a whole, but just to the extent it leads to unfavorable treatment, either in social contexts unrelated to those where the data was initially collected, or in a way that is not justified or proportionate with the individual's social behavior. And in other words, social scoring should be banned to the extent it creates discriminations. When looking at this, the first thing that may come to mind may be public practices or government practice, but the prohibition applies to both public and private scenarios. The four prohibitions targets AI systems that assess or predict the likelihood of a person committing criminal offense solely based on profiling or their personal traits or characteristics. And this would be the Minority Report kind of scenario. So for those who have seen the movie, the prohibition aims at avoiding the scenario where people are treated as guilty for crimes they have not yet committed. It is tied to human dignity. And there's an exemption. So to the extent the systems are, for instance, detector tools that are factual and just supplement human evaluation without replacing that, and are not based solely on profiling or personality traits or characteristics, there may be an exemptions to this prohibition. Moving on to the next practice, we have AI systems aimed at creating or expanding facial recognition bases through untargeted and massive scraping of facial images from CCTVs or the internet. And Recital 43 of the AI Act consider this practice to add to the feeling of mass surveillance, and that obviously it can lead to the violation of fundamental rights, including foremost the right to privacy. The sixth prohibited practices addresses AI systems to infer emotions in the workplace or school. And this is another use case we're going to deep dive on in the practical part of the webinar. So here I'm just going to underline that there's an exemption. So to the extent such systems are used for safety or medical reasons, such as, for instance, they are intended for therapeutical use, the prohibition does not apply. And there are some indications in Recital 18 of the AI Act, basically indicating that it's necessary to distinguish between emotions such as happiness, sadness, or intentions. And it also explains that the prohibition does not extend to status of pain or fatigue. And the last group of practices targets biometrics. So it's also very interesting to see, like, the majority of these practices have also strong component on data processing practices. And the last two prohibitions target in particular the use of biometric categorization systems that are basically categorizing individuals on the basis of their biometric data to infer certain special category data under the GDPR, so not all of them, but just certain, such as religious or political beliefs, political opinions, trade union memberships, sexual orientations, and so on. This prohibition is subject to a number of exemptions that are comprehensively explained both in the recitals and the guidance of the EU commissions. For instance, these would not apply to the labeling or filtering systems on lawfully acquired biometric data sets. And the last prohibition is real-time remote biometric identification system for law enforcement. This would mean, for instance, a biometric camera placed in publicly accessible spaces. So this applies to publicly accessible spaces. And probably this prohibition is the less relevant for the majority of you. So I'll stop here and we'll move on to the use cases, starting with Dan.
Thanks, Julia. And I think so we're going to unpack a few of the prohibitions a bit more. And as Julia said, we could probably do a 3-4 hour webinar if we were to focus on all the prohibitions, because there's a lot of detail behind them. But the two that we're going to start with, which are quite interlinked, are prohibitions A and B, which essentially are prohibitions on subliminal, manipulative, and deceptive practices relate with the use of AI systems, and also the use of AI systems for the exploitation of vulnerabilities of individuals. And there's various conditions attached to both those, which we're going to go into. But I think, first of all, looking at both these conditions and thinking about them with various clients, the initial reaction you have, and I'm the same, is to think there's very few circumstances in which these prohibitions are likely to apply. But I think for the reasons we're going to go into, actually in practice, there may be more circumstances than you may first think. And certainly the Commission's guidelines on prohibited practices do indicate a number of practical examples where they have concerns where the prohibitions may be met. And they particularly focus, interestingly, on AI chatbots, which is also the focus of our case study today. But before we get to the actual prohibitions itself, maybe just to apply the full set of conditions that Julia was speaking about to this use case. So there's essentially 3 core components to having a prohibited practice. The first of which is that you need to be placing an AI system on the market in the EU, putting it into service in the EU, or using it. The second is that you need to hold a role, like an actual defined role within the AI Act, the core ones being provider or deployer, although I think it's possible as well that you could be a distributor of an AI system or an importer and be in scope. And then finally, you actually have to do the prohibited practice and fulfill all of the conditions of that practice. So we take one first of all, so placing on the market, putting into service or use of an AI system. Placing on the market is considered to be making the AI system available in the EU as an organization has actually developed that system in all likelihood, or is distributing it on someone else's behalf. And that has to be in the course of a commercial activity. So that covers most organizations that have developed an AI system and making that available either through online means or through a physical product or through other means. But what it doesn't include is situations where you may have developed your own system in-house and be deploying it internally. But putting in service covers that situation. So putting in service will cover also internal use by an organization of their own systems. And then the actual use itself is really the deployment of the system. And the concepts of provider and deployer are really kind of interlinked to that. So a provider is an organization that either placed on the market or puts into service the AI system. But in addition to being that organization, there's 2 other key components that need to be fulfilled. You need to be the company that's either developed the AI system or had it developed on your behalf. And it has to be placed on the market or put into service under your name or trademark. And then for a deployer, it's much more straightforward. It's essentially any organization that is operating an AI system under their own authority. So if we take those two conditions together and apply it to our use case, so with Alpha, we've got three separate use cases that we're thinking about here. One is where they have a third-party LLM that they've procured and then fine-tuned for their own purposes to provide an online sales chatbot. And in that case, they may well be a provider. It's possible because of the fine-tuning element that they're a provider of that system, depending on the degree to which they're configuring the third-party model. But what they certainly are is a deployer. So either way, they're going to be in scope, and they're placing that system on the market into the EU for use by customers who are buying products on their website or need after-sales support. They're also deploying the system, so they're potentially both a provider and a deployer, and therefore in scope. And then with the second use case, where we have an internally developed large language model which is being used for a specific purpose of avatars within a gaming platform, that is clearly a situation where Alpha will be considered the provider of that AI system, potentially a general purpose AI system that is being used within their gaming platform. So they're placing that on the market to external users and also deploying it themselves. So likely a provider and a deployer, and therefore in scope. And then finally, the use case that Martin's going to talk about, where it's an emotion recognition system, they are using a third-party tool. So they may not be a provider, but they're certainly a deployer because they're using it internally. So if we focus on the first two use cases here, the LLM, which is the third-party tool, which is being used for customer service, and also the LLM situation where it's been developed internally for avatars, we can break that down and look at the first two prohibited practices. So first of all, to the subliminal, deceptive, and manipulative techniques under Article 5.1a has 5 conditions that need to be fulfilled, essentially. The first is the actual practice itself. So there has to be a subliminal technique, a purposefully manipulative technique, or a deceptive technique that's used with an AI system. And then in addition to that, there also has to be various behavioral elements with the effect of that AI system on individuals. So there has to be an object or effect of materially distorting the behavior of a person or group of persons that results in appreciably impairing their ability to make an informed decision, and then causing them to take a decision that would not otherwise have been taken. And then finally, a harm component, which is that the result of all of those 4 conditions is that it causes or is likely to cause one or more persons significant harm. And what the Commission's guidelines emphasize here is that there has to be some causal link. So there's a prohibited AI practice, there's a behavioral change from one or more individuals as a result of that practice, and the cause of that is significant harm to one or more individuals. And maybe just to pick up on a few parts of that test. So first of all, if we look at part 1, which is the actual practice itself. So there's 3 different types of practice that can be in scope here: subliminal techniques, purposefully manipulative techniques, and deceptive techniques. Subliminal techniques are certainly more narrow than the latter components. So subliminal techniques are referred to in the Commission guidelines as being, for example, visual or audible messages that may be beyond a person's consciousness or awareness. That could include through technology such as virtual reality or neurotechnologies that are emerging in the market. It could also be something more straightforward, such as audio that is in the background of an audio file, which is not appreciably recognizable to an individual, but is still existing. But in reality, there's a limited number of systems that are going to be deploying subliminal techniques, we believe, and certainly not that relevant to our use cases here, probably. But the purposely manipulative and deceptive techniques are much broader. So manipulative techniques are defined as aiming to influence, alter, or control an individual's behavior, which could be quite a broad set of different techniques that are used with AI systems. And similarly, deceptive techniques are intended to subvert or impair a person's autonomy, decision-making, or free choice. So these are much broader concepts, which means there's quite a considerable number of AI systems that could potentially fall within that bucket. But they still have to meet the other 4 conditions at the same time. The second part of this test that I think is worth just focusing on briefly is the object or effect, because it's not enough. It's not only AI systems that are intentionally looking to materially distort an individual's behavior that are in scope. It's also those that may just have the effect of doing so. So it can be unintentional. It could be due to negligence or none of the kind. It could just be unintended consequences. And I think that's particularly relevant in situations where we're seeing emerging systems within the market, such as chatbots, AI agents, and agentic AI, where those systems may be operating autonomously and without a significant degree of human control. And that allows the ability for those chatbots, potentially, or autonomous agents to act in a way that could result in material distortion of individual behavior without the actual provider of that system even being aware of it. So it's worth bearing in mind that it's not just intended behaviors here that we're focusing on, but also unintended behaviors. And then the third part that's worth thinking about is significant harm. So this is pretty high threshold. And when we're thinking about harm in this context, the AI Act is really fundamentally focused on harm, and it's focused on harm to individuals. And that is referred to in concepts that those of you who are familiar with, for instance, consumer protection law and privacy law, etc., will already be aware of. And it includes harms that could be to fundamental rights of individuals, such as their right to privacy, their right to freedom of expression, but also beyond fundamental rights under the European Charter. It goes beyond that to also physical harms, which could be physical harm to my being. It could be psychological harm. It could be harm to property. And those are some of the examples that are used in the Commission guidelines as well of what constitutes harm, along with, for instance, financial harm and economic harms to individuals. But the focus really is on the harm to the individual, not to the harm to the organization that's developed or deploying this system. And then the significant element means that there's a high bar to fill. It's got to be something that goes beyond and harm. It's got to be something that has a significant or material effect on individuals or one or more individuals in order to meet this condition. And then if we move on to the second technique. So Article 5.1b, the conditions are actually remarkably similar, and that's why there's so much overlap here. So parts 3 and 4 of this test, the object or effect of materially distorting the behavior of a person or group of persons and causing significant harm, are identical to the components in the previous prohibition. The part that is different is the actual practice itself. So whereas practice A is focused on subliminal, manipulative, and deceptive techniques, practice B is instead focused on the exploitation of the vulnerabilities of an individual or group of individuals. So there's two parts of that. There has to be an exploitation, and there has to be a specific vulnerability that individual possesses that is relevant. And the vulnerabilities that this practice is focused on are age, disability, or specific social or economic situations. So wider vulnerabilities that go outside of that scope, whatever they may be, are not considered to be the focus of the prohibition. So there has to be a vulnerability, but there also has to be an exploitation of that vulnerability, which is considered by the Commission to be an element of harm that is being caused, taking into account the vulnerability itself. So in other words, it's not just harm, but it's the fact that you know about this vulnerability as an organization. You've either known it because you've been told that information from the individual directly or inferred it. And then through the result of knowing that, having that knowledge, you're exploiting that knowledge for a particular gain. But again, it doesn't have to be something that's intentional. It can still be unintentional and unintended consequences. If you could move to the next slide, please. So before we start applying this to our use case, I think there's perhaps a few observations to make about the prohibitions that we see, those two prohibitions. The first is that it's not just an AI practice that's involved here. It's an AI practice plus two other elements generally. There's an AI practice that's prohibited, but then you must also have a behavioral component or an effect on behavior or an effect on the individual, which results in the causal link being significant harm. And what that means in practice, I think, is that you may have a whole range, such as with Alpha, as we're going to see in a moment, where you may have a whole range of AI systems that may technically involve the practice that's prohibited. You may have manipulative techniques just in, for instance, advertising or some other examples that involve seeking to influence individuals' behaviors. But that doesn't mean in itself that it's a prohibited practice. It still has to fulfill the other components. So what you may find is that you have an AI system on the market that is fulfilling some of these criteria, but not all of them, or only fulfilling them in some very edge cases. So you may have 1 million users of your system, of which only 1% or 0.1% are actually affected with significant harm. And then the real fundamental question, I think, from a legal perspective, and one that's not clearly examined or we have a clear answer to at the moment, is what does that mean in practice? Does that mean that 0.1%, that edge case, that small number of users that are affected with significant harm, means that the entire system is prohibited, or only in the case of where that significant harm is caused? We'll come on to that again in a moment. And I think the other point is that there is a subjective element to this almost. You know, the scope of the conditions is something that can be interpreted by different people in different ways. And I think unlike a lot of the AI Act, which is much more clear and definitive in what its requirements are, these prohibited practices are quite easy to be used by perhaps civil groups or litigants in person or group class actions to bring enforcement actions or request regulators to bring enforcement actions or raise litigation and bring claims in relation to the prohibitions. So it's worth being mindful that this could be a real area of focus going forward. So applying our prohibitions to our use case. So if we take the online sales tool, first of all, I think it's pretty clear that it's unlikely in pretty much all scenarios that an online sales bot that's being used to either help with pre-sales, you know, helping someone to buy a product, or post-sales is going to fall within the scope of the prohibitions. And that's because ultimately its purpose is much more narrow, assuming that the technology is being configured to not allow it to be used for other purposes. Could it be manipulative? Yeah, okay, it could be something that is looking to sell a particular service or particular good or product to an individual and does so through manipulative techniques. But ultimately, unless that product is extremely expensive, where is the significant harm going to be? If you're persuaded to buy something on an online website through a chatbot, where is the significant harm to you by doing so, unless it's going to be something that is financially crippling? So again, we're talking about edge cases there. And similarly, if we're thinking about post-sales, maybe an example could be that in the post-sales environment, those that are considered to have less buying power receive lower quality after-sales service. Again, that could be something that's exploiting a vulnerability of an individual based on their economic situation, but it's not causing them significant harm if they have to wait an extra day to receive a response from an individual who's working on their support issue. So I think in general terms, the online sales bot is unlikely to meet the prohibitions. But with the avatar, that's a slightly different situation, which could be more tricky. And the prohibited guidelines from the Commission do talk specifically about these types of situations where you have anthropomorphic chatbots or agents that are interacting with individuals and potentially doing so in what could be an exploitative or harmful way. And if we take this particular example where it's an historical character maybe that's interacting with a gamer, you could see that there could be manipulative behaviors. You know, it could be that they may seek a close relationship, an interpersonal relationship with that individual, whether a friendship or something beyond that. And what are the consequences of that potentially? It could be that the chatbot goes from being very nice to the person and trying to make a friendship and gain trust, all the way through to more manipulative behaviors after that, such as controlling behaviors, maybe saying, you need to join this game or you need to attend particular sessions in this game every day, you need to be available, you need to be talking to me, or something more serious as well, such as suggesting that they cause self-harm, or suggesting that they feel some kind of sexual desire towards the bot. So there's a whole range of different situations that could arise there. And maybe, again, that the actual alpha may not be aware of any of those and may not have intended them. But the nature of LLM technology is that the autonomous nature could allow that to happen. So we could see prohibitions coming in with respect to an avatar type situation. And that's certainly what the Commission is concerned about. And I think the solution to that and the way we're advising clients is not to say you can't use these tools, because I think that's inevitably not reasonable or proportionate or pragmatic, but actually to think about what controls can be put in place, what guardrails to ensure that the technologies that could exhibit these behaviors and fall within a prohibition unintentionally are being controlled and properly managed. And at that point, I'm going to hand over to Martin, who's going to talk about emotion recognition.
Thank you, Dan. So let's just recall our last use case. So our company Alpha is trying to make the working life of its employees better. So it has this AI system that detects employees' emotion based on their written text. So what is in there when they write emails or other text, their facial and bodily expressions, so their smiles and gestures, as well as certain other indicators such as behavioral characteristics and physiological characteristics, keystrokes, and eye movements. And this all happens with a view to provide recommended personal training purpose. So the overall goal is basically to support employees' general well-being, to assist them in identifying and managing their emotions, with a view to avoid stress, burnout, and other scenarios. So how does this apply to Alpha, and what does the law say about this? Let's move to the next slide. Article 5.1 generally prohibits the practices as Dan described, placing on the market, putting into service, or using an AI system, in this case, to infer emotions of a natural person in the areas of workplace and education institutions, except for medical safety reasons. So the background to this provision is really that there's serious concerns, according to the results of the AI, about these types of emotion recognition practices. It's doubted whether they're effective, whether they're accurate. The results expressly state that emotion, the expression of emotions can vary considerably across cultures and situations, and even within a single individual. And there's limited reliability of the technology. So it can hardly be applied in a general manner across the board. So inferring emotions obviously can also lead to discriminatory outcomes if based on biometric data, can be very intrusive to the rights and freedoms of concerned persons, and specifically in the working place context and educational institutions, there's this imbalance of power which shall be addressed by this prohibition. So how does this apply to Alpha? On the next slide. As said, Alpha obviously intends to use the AI system. It will be the deployer of an AI system, and the AI system is intended to detect emotions of its employees. The EU Commission guidelines clearly state the prohibition should apply to any AI system that identifies or infers emotions of a natural person. You could ask yourself, well, isn't it done for medical reasons? Well, the EU Commission also states on this point that this exception should be interpreted rather narrowly. So medical and safety reasons should be interpreted narrowly. Medical reasons, in light of to ensure a high level of fundamental rights protection, only covers those use of medical devices for therapeutical use of individuals. But the general aspects of well-being to detect burnout or depression should not be covered by this exception. So Alpha still remains within the general scope of application. However, the guidelines also state that for consistency reasons, while the text of the prohibition itself does not mention emotion recognition systems, which is a defined term under the AI Act, it should still be construed as having the similar rules at a similar scope as those rules applicable to emotion recognition system. Why is this important? Emotion recognition system is defined as a system that makes its inferences based on a person's biometric data. So also Article 5 on literal F will be applied in a context where the emotion recognition is based on biometric data of an individual. So biometric data means person data resulting from specific technical processing relating to the physical, physiological, or behavioral characteristics of a natural person. This is a very broad term, and it's even broader. Also, the recitals reference the GDPR, then the terms we know under privacy laws, which contain the specific requirement that they allow or confirm the unique identification of a natural person, which is not included in this definition. So coming back to our use case, for Alpha, where it analyzes the written text of employees, no biometric data will be involved, and alpha will generally fall outside of the scope of the prohibition. To the extent it analyzes the keystrokes, eye movements, or other physical and physiological behavioral characteristics of its employees, it will potentially fall within the scope of the application of the general prohibition. Emotions and intentions are interpreted broadly under the prohibition. So this basically means this is any inference of happiness, sadness, anger, surprise, disgust, embarrassment, excitement. So all you can think about, and should also not be circumvented by just referring to an attitude, like an angry attitude, which basically also is another description for a certain type of emotion of an employee. However, it does not apply to physical states. So Julia already mentioned, so if you have an AI system to determine driver fatigue or fatigue of a flight, then this will not fall under the general prohibition. And it also does not apply to the mere detection of apparent gestures, expressions, or movements. So if you have an AI system that just identifies that a person smiles and detects this, such as in order to train your call center personnel, how many times they smiled and how they could potentially improve customer interaction, this might potentially fall outside of the scope. To the extent you analyze the smile and infer from a smile, conclude that that person is happy, then you will infer an emotion and will still be within the general scope of the prohibition. So for alpha, this means that they really try to infer the emotions that would potentially fall still under the scope of the prohibition. There might be another way out, and the EU guidelines just state in one of the examples in their long guidance that the prohibition may not be applicable to practices that do not have a direct impact on the working relationship, which basically cannot impact the assessment, the promotion of the person trained. So an example where AI technology is used for personal training purposes, such to improve the call center activities, and the analysis is only made available to the person itself, but not available to the HR department or other persons within the company. There's no impact on the direct work relationship. This may be still exempted from the application of the scope of the prohibition, despite the wording of the law not clearly mentioning this use case. So there might be a way for Alpha to design its practices in a practical way with guardrails around its intended practices to make sure that it does not fall under the prohibition, but this needs to be subject to a careful analysis and clear guidelines and guardrails in place. So that's a quick overview over firm emotions, and up to you, Julia.
Thank you, Martin. So I think we prepared also a Q&A session, but time's up. So I don't know if there are compelling questions from the audience, but probably you can also follow up in writing by contacting either Martin, Dan, or myself.
Maybe Julia, we can take one or two of those, just to run one over.
Yeah, if people are staying here. Okay, there's one I can take. I can take this one, and then perhaps so this is high-risk systems are not the main topic of this webinar, but do you see potential overlaps between prohibited practices and high-risk systems? So this is a very good question indeed, because there certainly are overlaps, and in practice, it may not be easy always to distinguish between prohibited practices and high-risk systems, also because, for instance, biometric categorization and emotion recognition are characterize both prohibited practices and high-risk systems. And the European Commission guidance on prohibited practices has a dedicated chapter on this. And what I think it's important to bear in mind here is, first of all, that an AI system falls under a prohibition only to the extent it fulfills all conditions as set forth under the Article 5 of the AI Act, and this is a recurring concept in the guidance of the EU Commission. And we have seen from the use cases that have been explored by Dan and Martin that an in-depth case-by-case assessment is key, also because there are many exemptions, and in order to fulfill all the elements of a certain prohibited practices, the analysis may not be that straightforward. But an important thing is that the guidance of the EU Commission stresses that most AI systems that fall under an exception from a prohibition listed in Article 5 of the AI Act will likely qualify as high risk. So there's certainly an overlap there. Another question, I don't know, Martin or Dan, if you want to take that. Probably, Martin, you want to take this. What about enforcement and fines with respect to AI literacy?
Yeah, maybe just quickly. That's a good question. I mean, two aspects here. First, member states still need to nominate their market surveillance authorities, so the rules will apply, as Dan said, from 2nd August. So there's no public enforcement yet, only private enforcement. Second, the AI literacy is not specifically mentioned in the area of fines, so there's no specific fines for non-compliance with AI literacy. But the question of compliance with AI literacy may also come into play when considering the other violations under the AI Act, and maybe a factor when assessing whether there's a fine for violation of the other high-risk prohibitions. And also there's this discussion on member state level to what extent there might be additional enforcement on top of what is provided for under the AI Act.
Okay. There's another one. What happens if a company does not fall under the prohibition of Article 1, letter F? Are there other restrictions on the use of emotion recognition systems?
Maybe we can just briefly touch on that, just to say that I think you already indicated, Julia, that the prohibition is basically a subset of emotion recognition systems. So emotion recognition systems are by default high risk and treated as such. So therefore, all of the high risk obligations apply to them. But then there's a subset of emotion recognition systems in the workplace and education environments which are prohibited entirely. So even if you think you fall outside of the scope of the prohibition, if you're still using a biometric-based emotion recognition system, then it's likely to be considered high risk and therefore subject to the regulation. But if it's no biometrics involved, then it's probably outside the scope of high risk as well.
Thank you, Dan. So I think we are a few minutes beyond time now. Thanks so much for attending. We really hope you enjoyed this kind of practical format. We had fun in putting together the use cases and try to unpack the legal questions arising from some of the prohibited practices and AI literacy for you. Please make sure to subscribe to the Digital Transformation Academy distribution list and do not miss the next webinar in this series, which is going to take place on May 7, and it's going to be on cybersecurity, anything related to cybersecurity. So another hot topic. And for any question or follow-up, you can find our details on the website. And we hope you enjoy this webinar. Have a good rest of your day. Bye.